And yeah, good morning, good afternoon, and good evening, depending on where you're joining us from today. And welcome everybody to the first part of our webinar series on COVID-19 vaccinations and international law. My name is Lisa Cohen, and alongside my colleague Ruth L, I will be moderating today's webinar on the COVID-19 vaccination gap, a global and interdisciplinary issue which has rightfully received heightened attention lately. And the COVID-19 pandemic, as you all know, has been a dramatic reminder of the fact that health is a global public good. However, since the first vaccine hit the market in late 2020, phenomena of vaccine nationalism and vaccine diplomacy flourished, while the unequal distribution of COVID-19 vaccines across the globe stirs up the fear of a sustained vaccine apartheid and an increase in poverty and global inequalities. So on behalf of Ruhr University Bochum's Institute for International Law of Peace and Armed Conflict, our research cluster on human rights and humanitarian protection, as well as the European Society of International Law's interest group on international human rights law, it is our great pleasure to take you through a discussion on pressing issues surrounding the COVID-19 vaccination gap with our really distinguished guests, which we're really happy to have, Professor Diane Desierto, Professor Ruth Okediji, and Professor Matthew Kavanagh. Welcome.
Yes, good afternoon, good morning, and good evening from me as well. It truly is a pleasure to be welcoming both our distinguished guests and our digital audience from all around the world today. Let me shortly brief you on some technical details for this webinar. After the presentations of our panelists, we will have time for the audience to pose their questions to the panel. Please feel free to submit any questions you may have at any time through the Q&A function at the bottom of your screen. Please also indicate if your question is directed towards one specific panelist or rather to the panel as a whole. We will then collect and group your questions if necessary and post them to the speakers in due time. One last point, the webinar is also live streamed on the Völkerrechts blog, and a recording of the event will be made available. Before we begin with the presentations, let me now introduce our Institute's Executive Director, Professor Pierre Tielberger, who will set the stage with some introductory remarks. Professor Tielberger is Professor of German Public Law and Public International Law at Ruhr University Bochum and Chair of the European Society of International Law's interest group on international human rights law. Pierre, you have the floor.
Yeah, thank you, Ruven and Lisa, for this kind introduction. Welcome to our three distinguished panelists. I want to start by saying that I'm very impressed that, young researchers like yourself, PhD researchers like yourself, came up with such an event. And I think that's really amazing. And it's maybe also something that COVID has brought to us, that somehow hierarchies are becoming even flatter. And it's amazing that, the scholarship of the very, very established scholars like our guests today and junior scholars is really become so close. I find that really amazing. Yeah, so I was only given less than 5 minutes. That was my task. The other speakers have double the amount, so I'm not going to address anything in substance. I'm going to do two things, essentially. One is to welcome you again on behalf of the European Society of International Law. They wrote to me again this morning to make a bit of advertisement for them and say, if you don't know what the European Society of International Law is, look it up on their website, become a member. It's a very important organization, Europe's biggest academic organizations for academics, practitioners working in the field of international law. And it's really an amazing organization. So if you have time, look it up. And of our second host, which is the Institute for the International Law of Peace and Armed Conflict, which is Germany's biggest research institute in the field of humanitarian law and human rights, located in Bochum. So that's the welcome. The second part is a bit setting the stage for the inputs that will then follow, the more academic inputs. So I want to give you a bit of an overview of this topic of the so-called vaccination gap without going into the international details that our speakers will then do. And I want to at least remind you that we have seen in COVID great challenges. We are all aware of that, but we have also seen quite remarkable achievement, right? And that is the development of these vaccines in a record time. Yeah, so we have these, most of them are highly functional vaccines, and they were developed with a lot of financial support of governments by several companies in short time span, more or less a year only. And at the same time, apart from the scientific success, we see something which is maybe not surprising, but still interesting to note, which is, how governments have prepared for the day these vaccines would come onto the market. Because they have, of course, made sure that enough vaccine doses would be reserved for themselves. Some states have done that better and some states have done that worse. I'm saying that as a German citizen, because the German state for a long time was criticized for this. And it is quite remarkable if you look into the numbers. I think that is also interesting to look at, that in now 6 months into 2021, we see that many of the wealthy states in Europe and Northern America have really reached quite remarkable vaccine rates. So if I just quote from the New York Times a few days ago, recent numbers, so Israel has now almost fully vaccinated, I should say. So with 2 shots, if it's one of those vaccinations which requires 2, of 60% of its population. The US is currently at a rate around 45%. And even Germany, as I said in the beginning, quite slow, has now reached more than 30% of fully vaccinated people in the population. So in some of these states, the problem is actually more how to convince more people to get vaccinated rather than to find the vaccines. And we see these almost absurd motivations in some states to motivate more people, to give them free beer, or I read even free marijuana in some of the states, or participate in a lottery, to increase the number of people who want to get vaccinated. And why do I say that this is a bit absurd? Because if you then look into another part of the world, where you have governments who just can't get these vaccines or they can't afford these vaccines. So just to give you other numbers, if you look into states in Africa, Cameroon, Mali, Congo, for instance, there we have a vaccination rate of less than 1% at the moment. Right. And that means that even people working at the front, at the medical front, like nurses, doctors, not even they are vaccinated, right? And that's, of course, a huge problem. And we, I think, have to come to understand that this will prove fatal in the end, because we will have to address this problem in all parts of the world. I'd like to quote here Peter Pite, who some of you might know, a famous microbiologist who has made his name in the HIV and Ebola research, who said the pandemic is not going to be over until it's over everywhere, right? And I think that is something that is important to keep in mind. So then, of course, the question is what could be done? And I think now this is the last part, because in detail, I think some of you, I'm sure Diane, for instance, will address these issues. Well, one thing I think you all have heard about this COVAX initiative, right? That is certainly one way of addressing the problem. How good it is, we can discuss later, which is essentially a collaborative platform where people come together, that country contribute differently to, and then the developed vaccines are spread between the different contributing states, mainly dependent on their population, not on their contribution. And that is in some ways, if you just look at the numbers, quite a success. More than 70 million, I believe, doses have been delivered this way. 10 billion US dollars, I think, have been raised this way. The US has recently made a pledge again here. So at least we see some movement here. And the other interesting thing I think I'm sure we will hear about is in the field of intellectual property, which is, of course, to say, what could we allow economically weaker nations to produce their own doses instead of relying on the more expensive doses from developed states? There is this proposal on the table, initially launched by China and India, but it was not met with support by all. In particular, from a European perspective, I have to say it has been the Europeans, Switzerland, Germany, and others, who have been very much against such a proposal. And that is quite interesting, I had to say, as an observer, as a human rights generalist, more than an expert in this specific topic, that it was not the Americans who were blocking this so much, but the Europeans. I think that's quite a remarkable thing to notice here. But again, as I said, I'm not an expert. I'm just a human rights lawyer in general. I'm very much excited to hear what our three experts have to say. If I understand correctly, the first to take the floor will be Diane. I have, of course, read also your contribution on Each Talk. I'm very interested to hear what you have to say about this. Thank you very much. And congratulations again to Lisa and Ruben for putting this up.
Yes, thank you, Pierre, for this introduction, which perfectly set the stage for what's to come and made at least me eager to dive into the presentations and the discussion. So without further ado, we want to welcome the first panelist of today's webinar, Professor Diane Desierto. Diane is a professor of law and global affairs and faculty director of the LLM program in human rights at Notre Dame Law School, with a joint appointment at the Keough School of Global Affairs at the University of Notre Dame. She's a member of the expert group of the United Nations Working Group on the Right to Development, editor of the international law blog Each Talk, and she serves on several editorial and scientific advisory boards for law journals. Diane has litigated as counsel before various international forums and is renowned for her expertise on international law in general, especially international economic law, human rights law, and development. Diane, we're very much looking forward to your remarks, and the floor is yours.
Thank you very much, Lisa, and thank you, Ruben and Pierre, for the invitation and the generous introduction. I myself am looking forward to this iteration of the discussion, especially given where we are at the present moment with the landmark developments. And I'll point to two landmark developments in the international arena that we could not have expected at the beginning of the distribution of the vaccines, actually. And that is, first and foremost, that the United States, as pointed out by Pierre, would be the first to support the mass distribution of vaccines through the COVAX facility and would commit to it. And the second, especially on the TRIPS waiver issue, and the second is that the multilateral organizations themselves, the WHO, the WTO, the International Monetary Fund, as well as the World Bank, would collectively release a statement before the G7 summit held recently that they are committing resources to basically vaccinate every arm in the world. The goal is to vaccinate everybody. At the time when we were initiating discussions about vaccine nationalism, especially on Each Talk, there was tremendous resistance to the idea that there could be any binding international legal obligations that mandate this kind of mass access to vaccination. And still, what I'm going to say is, with respect to those two developments, neither the United States nor the multilateral organizations, neither of them have said that they are doing or acting on the basis of international legal obligations, especially on human rights law. So much of this is humanitarian, so much of this is seen as policy that is necessary to stop the global pandemic. But what for me, and my intervention for these 10 minutes, what for me is ultimately more concerning is that when the vaccination strategy is anchored on political policy, on what is politically expedient rather than what is legally required under international human rights law, specifically the Covenant on Economic, Social, Cultural Rights, we're going to continue to experience variations, logjams, and differences in the scale and distribution and access to these vaccines. So on that premise, let me focus my remaining 7 minutes or so on where the law is, where human rights law is on this subject. Because I've had the occasion to discuss this several times, and I have had the experience of others who have resisted the idea that the Covenant on Economic, Social, Cultural Rights could be in any way applicable here. If I may share my screen, I'm just going to briefly show the status of ratifications for the International Covenant on Economic, Social, and Cultural Rights. Let me just check briefly if I can share my screen. Well, looks like my screen share is disabled, but let me just point to the fact that most of the world, including Europe, is a party to the International Covenant on Economic, Social, Cultural Rights. There are 3 provisions of this treaty, this human rights treaty, that are implicated with respect to the issue of the TRIPS waiver and vaccine waiver, vaccine access. First is the core obligation under Article 2, Paragraph 1 for every state to undertake steps to ensure through international cooperation or assistance that in particular, there would be a move towards individual efforts and cooperation to progressively realize all covenant rights to the maximum of one's available resources. The second is the non-discrimination obligation under Article 2, Paragraph 2, which does require all states parties to this covenant to guarantee that the rights enunciated in the covenant will be exercised without discrimination on prohibited grounds as to race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. The third norm that I will also point to is Article 12 on the right to the highest attainable standard of physical and mental health, and specifically 12 Paragraph 2, Paragraph C, which says that the steps to be taken by states parties to this covenant to achieve the full realization of the right to the highest attainable standard of physical and mental health includes those that are necessary for prevention, treatment, and control of epidemic, endemic, occupational, and other diseases. Now, just using those 3 norms, it should be quite clear that what's been transpiring in these circumstances, or at least in the last few months that we've seen vaccine distribution and vaccine initiatives, whether through the COVAX facility, which is also a voluntary facility that was set up by the WHO, and it is not also done, and it's not also premised on human rights law. It is seen primarily as a cooperative instrument that's not undertaken by states out of a sense of legal obligation. So it's a humanitarian effort. States are free to join, but it's not out of a sense of legal obligation or certainly not moral or moral requirements as we have in human rights law. If we took the non-discrimination standard seriously, and particularly the core obligation not to discriminate in regard to taking steps individually and through international assistance and cooperation to the maximum of a state's available resources to progressively realize the right to, among others, in the Covenant on Economic, Social, Cultural Rights, to the highest attainable standard of physical and mental health, especially as it includes the prevention, treatment, and treatment of epidemics and other occupational diseases and control of occupational diseases. We see that what's happening at the moment falls far short of the international standards. This is probably why the resistance of the European nations, European states, to the TRIPS waiver is quite baffling, because if they took their obligations seriously under the Covenant on Economic, Social, Cultural Rights, which, by the way, the United States is only a signatory to this covenant. It's not even a full party, and yet it's already acting in support of the TRIPS waiver, unlike the full states parties who are the European states themselves. Where does the discrimination occur? And the discrimination is occurring on systemic differential treatment based on a prohibited ground, several prohibited grounds, especially when we consider the extraterritorial application of the Covenant on Economic, Social, Cultural Rights as recognized by the International Court of Justice in the Wall Advisory Opinion. The discrimination is taking place on the basis of race. It's also discrimination on the basis of other status, in discrimination on the basis of one's geography and where one in particular is born, and discrimination on the basis of property. we think about who has access to the vaccines and the pricing mechanism for these vaccines, the differentiated, segmented pricing for these vaccines, I can tell you now that at least for my relatives in the Philippines, access to a US-made vaccine is going to cost several $100,000 pesos, which is prohibitive given the fact that here in the United States, we have supermarkets who are trying to incentivize people to please get vaccinated for free. We'll give you groceries on top of it all. I mean, just the sheer stark unreality of that already should make it clear that this is a situation more than any other where geography, birth, one's property, and one's personal status now determines whether or not we have access to the right to the highest attainable standard of physical and mental health. And the obstacles that persist with respect to international cooperation and efforts on an individual and international assistance basis under the Covenant on Economic, Social, Cultural Rights is now contingent on political discussions at the multilateral institutions, which have a corresponding lag of time. This is why, as I said in previous discussions at EGIL Talk, it's all very well and good and great that you have multilateral institutions who commit the resources, but it's not just about committing the resources. States themselves do have to commit to the prevention, the treatment, the control, taking those steps to prevent, treat, and control epidemics and endemic occupational diseases. And the fact that today's main stumbling blocks are enabled through regulatory actions by states in regard to the vaccine manufacturers, in regard to the entire system of patent protections, in regard to most especially the refusal on the part of European states to agree to take action, international action at the TRIPS Council, is something that clearly establishes that the non-discrimination standard is continuously being breached by the failure to act on the part of the full parties to the Covenant on Economic, Social, Cultural Rights. There's a lot of other things I could say here, especially on the particulars of what is required under the TRIPS waiver. But since we have Ruth in the panel and Matthew in the panel, I would be glad to defer to them on the specifics. I can approach it from the international economic law and human rights standpoint. But let me begin with that and continue with the discussion. Thank you.
Thank you so much, Professor Desierto, Diane, for this insightful presentation. My main takeaway is that it really is not a political question, but rather a moral, or better put, a legal obligation to share vaccinations. I'm sure we will get back to that during the Q&A section, but let us now continue with our second input for this webinar by Professor Ruth Okediji. Ruth is the Jeremiah Smith Jr. Professor of Law at Harvard Law School and co-director of the Berkman Klein Center for Internet and Society at Harvard University. She's the editor of the Journal of World Intellectual Property Law and a member of the American Law Institute. She's one of the leading experts in the field of international intellectual property law and has advised numerous intergovernmental organizations, regional economic communities, and national governments on a range of matters related to technology, innovation, policy, and development. Ruth, we are looking very much forward to your remarks. The floor is yours.
Thank you so much. And I am going to share my screen so that I can talk fast. Those of you who are watching through the live stream, I hope that you can write fast and tell your ears to listen fast. So thank you so much for the invitation. This is such an important topic. It is still a vital challenge for the global economy. And as Diane has just mentioned, a matter that is profoundly troubling from the human rights perspective. I have on the screen in front of you a picture of school children in Kenya who are sort of jumping and skipping and doing what school children do past a mural of the COVID-19 virus. So if you look at the nurse in the PPE chasing, trying to slow down with a chain this virus that's running after the world. And this mural is interesting to me as an intellectual property scholar, but really as someone who spent a lot of time thinking about access to medicines and access to vaccines today. As we heard earlier, the rate of vaccination in sub-Saharan Africa is abysmal, absolutely abysmal. And the numbers suggest that it will be 5 years at the earliest, 5 years before that region of the world is vaccinated. Many of you saw last week, towards the end of last week, the New York Times article and in several other outlets of the death rate over 500,000 in Brazil. We are seeing essentially a pandemic of significant proportions globally that is wreaking havoc on families, on nations, on lives. The untold consequences economically, psychologically, are really quite profound. It's not beyond the numbers of tragic deaths, the children with no parents, the hospitals, the infrastructure that cannot sustain the outcome and the consequences of this is profound. And the reason for that is that we have a persistent, and some may argue growing, vaccine gap. One of the challenges in the sub-Saharan African region is portrayed in this picture with many aspects of the society becoming accustomed to the virus and assuming that there will be no way out. They'll either get it and survive or get it and die. But there is a acceptance, a tacit acceptance that this is the way the world works. So let's continue going to school and doing what we can do, even knowing that our lives are at risk. And of course, because I'm speaking about intellectual property, I want to really zone in on what are the rules. Diane has looked at the founding rules in the human rights arena, the trade-related aspects of intellectual property rights, the TRIPS agreement, which entered into force universally in 1995, essentially creates a minimum standard for every country of the world that is a member of the WTO to adhere to. Article 27 requires countries to mandatorily make patents available for all inventions. That provision allows countries to exclude from patentability certain inventions necessary to protect ordre public, morality, or to protect human life, or to affect serious prejudice to the environment. But by and large, the rule in Article 27.1 is that everything should be subject to a patent. Diagnostic and therapeutic and surgical methods can also be excluded in plants and animals. But if you look at the breadth of Article 27.1, it's mandatory that nations provide these patent protections. It is for any and all inventions, including pharmaceuticals, for products and for processes in all fields of technology. Now, that's a property rule. It mandates that every country who's a member of the WTO give these property rights to inventors. What's the nature of the rights? They are fairly robust. The exclusive right to make, to use, to offer for sale, to sell, to import. So any access to a patented invention means that you need permission to do any of these things, to make, in the case of pharmaceutical drugs and in the case of patented vaccines, to use, to offer for sale, to sell, to import. These are things that are conferred by a patent grant. Now, it's interesting that even though there are conditions on patent applicants that may make access to knowledge and the possibility of reproducing patented goods possible. For example, the obligation to disclose the invention so that someone skilled in the art might be able to reproduce it. The possibility for countries to require an applicant to provide information about what other countries are you seeking rights on. The reality is that many countries in the global South simply do not have the science and technology base or the technical capacity to replicate, even if the disclosure was made. Now, the state of quasi-monopoly is 20 years. The virus that we are dealing with today can take a life in less than a week. Even with the vaccine, we are still seeing consequences of what we call the long haulers who are reacting and continue to need other kinds of medicines to sustain their lives, even if they have not caught even if they have not died from the vaccine. So since the TRIPS agreement, pharmaceutical companies have challenged the sovereign power of states to formulate and implement autonomous health initiatives. And basically they've done so in ways that are quite legal. So to Diane's point, while our response largely through COVAX and other means to the pandemic has been humanitarian and voluntary, the resistance to a robust legal system, a framework that would facilitate greater autonomy when it comes to public health, is grounded very much in legal regimes. So for example, pharmaceutical firms have argued that states can only invoke a doctrine of national exhaustion, which means even if you don't have the patent, you have to protect it rather than international exhaustion. TRIPS has narrowed a state's rights to impose compulsory licenses. This is what pharmaceutical companies are arguing, that states lack the power to impose compulsory licenses, and that TRIPS in general has limited states' powers to implement IP rights in a flexible manner. So in sum, the arguments that have been made are grounded deeply in law, in an interpretation of the text of the TRIPS agreement, not necessarily involving other international regimes like human rights, but deeply undercutting some of the fundamental assumptions of the international order, namely state sovereignty. Right? The idea is, well, you've given up your sovereign right to legislate in a manner that would advance the public health needs of your country. And it's grounded in the intellectual property system. And so what we have seen since 1995, while the COVID-19 vaccine is a global vaccine, there have been other pandemics limited to nation states. So public health crises, not every public health crisis is a pandemic, but public health crises are human rights considerations, and they affect the quality of life that citizens have to live. So what we have since 1995 is a stalemate situation, a situation in which governments in weaker countries in the global South were not willing to bring legal action, even though the arguments of pharmaceuticals and of developed country members of the WTO were not necessarily consistent with the text of the TRIPS agreement. Governments were unwilling to run the political risk of bringing legal action to vindicate the outcomes and the rights they would otherwise be entitled to under the TRIPS agreement. Now, of course, as many now know, in 2001, we had the HIV/AIDS pandemic. So we are, as a global society, in a system of law that produces outcomes that undercut the human rights and the human rights regime and the expectations of the basic rights, the fundamental rights that people all over the world should have. And when we have the HIV/AIDS pandemic, that produced this crisis, the first intellectual property public health crisis, when thousands of people were dying daily in South Africa because the government and people could not afford access to antiretrovirals. That produced this crisis in legitimacy of the TRIPS agreement, resulting in the Doha Declaration of November 2001. Now, as many of you know, the Doha Declaration was meant to clarify that countries, in fact, notwithstanding what pharmaceutical companies might argue or developed countries might argue, the countries have, in fact, room within the TRIPS agreement to autonomously address public health needs. And with regard to access to medicines, that there would be these parallel imports so that each country could use the flexibilities inherent in the TRIPS agreement to address public health needs. However, these compulsory licenses and many of the exceptions in the TRIPS agreement remained and remain to this day controversial, and the leverage that has accentuated the power of these exceptions on the TRIPS has been the human rights regimes. Now, what's interesting, of course, is that that very declaration said countries still have a duty to provide incentives to their institutions and to their enterprises to transfer technology, to make sure that there's a less of a technology gap so that countries are able to address public health or other access needs. But legal barriers still remain in place. And so we know that we saw the first waiver under the Doha Declaration regime in the form of Article 31F. But of course, that waiver just converted to a permanent amendment of the TRIPS with the waiver that was still in effect at the time. So the idea of a waiver in order to facilitate access to vaccines, access to medicines is not new. We've been dealing with this situation since 2001. Now, I want to very quickly in my last 3 minutes sort of talk about how this has worked in the past and why it presents a problem today. Essentially, in order to use a waiver, you need the cooperation of both an importing and an exporting country, and you need to have the capacity to manufacture. This was a challenge under the HIV/AIDS pandemic, and it is a challenge today, even with a waiver for purposes of vaccine production, because you need two countries, and most, as we know, Germany still is resistant to the idea of a TRIPS waiver, and of course other countries, and because the system works on a system of consensus, this is a problem. But you also have the lack of capacity. A waiver, as I've argued in some of my own work, is not going to automatically bridge the vaccine gap that we have today, because developing countries and least developed countries need regional agreements. They need capacity, they need scale, they need technical knowledge to actually produce the vaccines. So the human rights question always, in my mind, comes too late. The human rights question, if it's only arising when the pandemic, when the crisis hits, it has not exercised its moral power to restructure the basic rules of the international system to ensure that the access problems do not persist. It's a question of political will. Will countries with capacity be willing to help and to play by the rules to ensure that there's sustainable access to vaccines? So what we see is that since 1995, there's been a radical reshaping by law of the legal landscape, and developing countries and least developed countries really don't have much to do without being able to exercise the exception to their patent rights and working with the cooperation of countries who have the technical know-how and who have the patented technologies, who are willing to scale up the production locally of the drugs that are needed to address the public health challenge. On the screen in front of you to conclude are the relevant exceptions to patent rights and the nature of the policy problems that they address. Human rights law does not speak specifically to these exceptions, and as a result, every exception has to be negotiated legally with no countervailing specific legal norm to address the challenges of a property regime that de facto produces the kind of vaccine gap that we experience today. So it's important, I think, to note that the vaccine gap is not an accident, nor is it an unexpected outcome. It is designed. Its design is explicitly set up for in the international IP system, and the structural conditions that produce a lack of access to essential medicines are directly related to the underlying rules of the international economic system. And so the persistence of this gap reflects the limits of human rights and the urgency of reformulating the human rights intellectual property interface. What we are dealing with is a network of rules and norms and institutions that have sustained the legality of an intellectual property system that is not well suited or equipped with the fundamental human rights norms that would make a redesign of the system plausible or possible to address what is now clear to be one of the greatest challenges of our time.
Thank you, Diane, for this very, very interesting and food for thought presentation, especially regarding what can we do with regard to the inherent flaws of the international IP law system. And just a little reminder for our audience that you can, of course, already post questions through the Q&A section on the bottom of your screen, and we will then come back to those questions later during our Q&A section. And now, last but not least, we want to give the floor to Professor Matthew Kavanagh. Matt is Professor of Global Health and Visiting Professor of Law at Georgetown University and the Director of the Global Health Policy and Governance Initiative at the O'Neill Institute. He currently serves on the Scientific and Technical Advisory Committee for UNAIDS and as an advisor to the Health Global Access Project. His extensive research and writing focuses on the political economy of health policy in low and middle income countries and the political impact of human and constitutional rights on population health. Matt has previously advised the WHO, US State Department, and various NGOs on human rights and global health policy. Professor Kavanagh, we're looking forward to your remarks, and you have the floor.
Thank you so much for that, for the introduction and for having me, and to the organizers and to the two previous presenters. It's an honor to be with such brilliant folks. Let me go ahead and also share a brief presentation as I talk. So I'm going to go ahead and share a screen as well as we go here. So I think the place to start is really to say that the current global efforts at vaccine equity at this stage, as we've heard from several folks, we just need to be honest that they've failed. We have not achieved equity. And I think it's important to just hold that in our minds because that was in fact the goal. And while there are lots of conversations around what do we do now, how do we address the kind of situation we are in, where might various efforts deliver doses, the goal taken a year ago, more than a year ago, was to achieve vaccine equity through our global mechanisms. And that has not happened, right? And so we can see, for example, that here in this graph, you can see that the kind of, the global idea here is that all people in the population are able to get 2 doses of the vaccine or the equivalent of 2 doses if it's Johnson & Johnson. And here you can see that high-income countries are clearly dominating. They are already at the place where, for example, in the United States and Germany, more than half of people have gotten have at least 1 vaccine dose. Here in the United States, we're in a situation where 78% of seniors have gotten a dose. Essentially all of our healthcare workers have been covered. And yet, in low-income countries, 0.4% of the vaccines have actually reached arms. In Africa, in the continent where countries are struggling to get access, countries in Africa have essentially the amount of vaccine they would need to cover 15 to 17% of their priority populations, the ones that are already entirely covered in high-income countries. So the idea of equity has not been achieved. We need to talk about what to do about that. Also, just writ large, and noting, as Ruth was saying previously, the remarkable disconnect between a headline in the New York Times saying, oh, what a miracle summer is going to happen in wealthy countries, while the huge spikes are happening in Latin America, Africa, and Asia, and various parts of the world. So the core question then becomes, how did we get here? And so I'm going to talk, following on what Ruth and Diane described, really about the intersection of law and politics. How did we get where we've gotten and why, right? We can think in political science, we often talk about pieces that include this idea of agenda setting, right? What options have been put on the table, what options have not been put on the table as a legal and policy response. And in this case, the dominant agenda has been set by a group of actors, right, who had a very particular set of policy goals, right? And so in April of 2020, really two visions were offered for how we might address the law and policy questions in front of us to achieve equity. The first is what I call a demand-side law and policy paradigm, right? We could also call it a voluntary paradigm, a monopoly-based paradigm. And with that said, as you can see here, this is the ACT Accelerator that was launched in April of 2020. It was launched by the president of the EU and France, the Bill and Melinda Gates Foundation, the Wellcome Trust, the heads of WHO, Gavi, UNICEF, CEPI, and others. And what that paradigm said, right, was that we were going to focus on ensuring kind of what economists would call effective demand, that we needed to have advanced purchase agreements that would enable countries to be able to buy ahead of time. Even this was before the effective vaccines had been found, and we weren't sure which one was going to work. They also needed pooled procurement to increase the purchasing power and leverage of low and middle income countries. And that would be used to negotiate with countries who were making the vaccines, that we would use market-based incentives to get the scale up of production that was needed. And then it relied on appeals to funders to address the questions of low-income countries and to ensure that it would happen. It's important to note that these structures are voluntary structures, right? And kind of similar to what Diana was describing, that the realities here, right, is that they don't depend on the use of state power and law at all. In fact, they depend on the monopolies continuing and of the creators of the vaccines. And the idea was that there could be negotiations there. Now, there were on this a number of conversations that basically lots of talk about vaccine equity, including talk about vaccine equity as a global public good. And I think it's important to pay attention to what these words mean, right? Because if you ask economists, what is a public good? What you find, right, is that we need to be talking about things like whether or not it is, it is excludable and rivalous, right? Is the good actually open to all people who may need it, right? And so this approach is not a public goods approach, right? We should just be clear on that, right? This approach is a monopoly approach, right? In which the good itself is actually excludable. The good itself is the actual doses. And so what we built the law and policy paradigm around was that doses were going to be shared and that we were going to focus on the limited amount of doses. And so the focus of the law and policy intervention had little to do with the knowledge, right? Had little to do with the ability to make vaccines. That's a very different paradigm. And it's interesting because the idea of a public goods approach through law and policy is actually very attractive here. The United States paid $2.7 billion for the Moderna vaccine, for example. That's 99% of the funding that it took to make the Moderna vaccine. Interesting fact, the other $1 million came from Dolly Parton. Right, so thank you, Dolly, and thank you, United States government. Right, so this is where the vaccine came from. It was jointly developed with the National Institutes of Health, right, and it was actually Dr. Barney Graham and his colleagues who, after Chinese scientists discovered the genetic sequence, they tweaked a vaccine that they had been working on with Moderna, sent it off, and they tried to figure out how to make a vaccine. This is a publicly funded science. The same is true for a significant part of the Johnson & Johnson vaccine. Europe paid for much of the development of the BioNTech vaccine. The AstraZeneca vaccine was created by Oxford, which to my understanding is a rather, through public funding. And so we're talking about public goods in that sense, that they were funded and created by public goods. What you would think about a policy approach to that is what we might call open source, right? That we could think about it kind of the opposite of what Professor Okediji was talking about, right? The idea of an open source policy approach could have been taken. But instead, this was not the COVAX approach, right? The COVAX approach has been that each manufacturer retains a monopoly. They retain the IP, the trade secrets, the knowledge is kept secret, and those folks get to decide who will and who will not make the vaccine. And so there have been various licensing agreements, but the monopoly is maintained. What's not on the agenda, and we just need to kind of be clear about this, from a law and policy perspective, not on the agenda is a variety of the pieces, including what others have have talked about, right? And so, it's worth noting, right, that this alternative policy paradigm was in fact talked about, has been talked about, and has political support, right? So President Cyril Ramaphosa of South Africa, Prime Minister Imran Khan of Pakistan, President Macky Sall of Senegal, at the same time that the COVAX initiative was being launched, they put together a call that they called the People's Vaccine, right? They called for a much more open source approach. And that found purchase in a number of different policy efforts, including the creation of the COVID Technology Access Pool, the CTAP, that was created by the World Health Organization. And it's worth noting, right, what's really interesting about these paradigms is that the WHO sits in both, right? The WHO has said, we're part of COVAX, but we also want to see an open approach. But besides that, you almost see Venn diagrams in which the World Health Organization is almost the only overlapping organization, right? On the one hand, you've got wealthy countries. On the other hand, you've got the global South and countries, low and middle income countries. This was proposed by the president of Costa Rica. In October of 2020, as Ruth was saying, India and South Africa proposed the waiver, right? And so we can think about the three elements that would be needed to produce more vaccines. If you focus on supply, you focus on open, you'd need an IP waiver so that there's legal certainty, right? So that producers can go about their business. You'd ideally want to pool technology, right? So that the publicly funded science would be put into the center and said, anybody who wants it, here's the information about how to make it. Any factory out there that's certain quality can make the Moderna vaccine, can make the AstraZeneca vaccine, go for it, right? So, and the information is there so that we know that their quality is there. We've got quality certainty, right? And then funding to invest in factories. This would be the exercise of state power through the use of law. And it's important to note that governments have law and policy options to compel each of these pieces. So Ruth's already talked about some of the IP pieces, but it's also just worth noting that because these are publicly funded technologies, the United States, for example, could deploy the Defense Production Act to actually compel the sharing of the know-how about how to make the Moderna vaccine, right? The NIH actually, it turns out, owns a patent because it was developed jointly with the NIH, actually holds a patent on the Moderna vaccine that also Pfizer and BioNTech require to actually produce it. So it could use that as leverage, right? There's marching rights under what's called the Bayh-Dole Act in the United States that could allow for a compulsory licensing. So there are legal and policy tools that are available to states that are, the choice has been not to actually use them so far. In my final couple minutes, let me just say that I think the key here is that we've ended up with these two competing policy paradigms, and what we need is a political analysis about this, because some policy paradigms fit with politics, some policy paradigms don't, right? And so what we've chosen is the current paradigm. We have to ask, does it align with domestic political pressures? Does it address the policy goals that are advanced by powerful countries? And does it depend on weak norms? And in this case, all three of those are true. So for example, this is the outcome. This is a picture of the doses of COVID vaccine versus the populations. And all the orange dots have less than 2 per person. And all of the blue dots have far more than 2 per person that they've actually ordered, right? Because what we saw is that the domestic political incentives were cover your entire population. We know that from the start. Despite the nice statements in the global context, despite the kind of statements about a global public, there was no enforcement mechanism, as Diane was describing, right? And so here we're in a situation where the norms are very weak. We lack international binding obligations. It's remarkable that the legal paradigm that Ruth is talking about at the WTO is exactly the opposite of this, right? It's a hard binding obligation with mechanisms for compliance. Right now, it's not the same as domestic law, but it is a very different paradigm than anything approaching the idea of sharing collective doses. Right. And so here we're in this situation where even if there had been a pandemic treaty, it's not clear that it could have overcome vaccine nationalism. A core understanding of how we do law and policy has to incorporate an understanding that domestic political pressures are far stronger than international pressures, right? And all of the talk about global norms, when faced with a kind of massive and powerful domestic push, are going to fall away. And that's exactly what happened. No head of state from a high-income country ever said that they would do anything besides procure 100% of their population's vaccine doses. They never said they wouldn't do it. And you know what they did? That's exactly what they did. So this is not a surprise. I'm confused about people who are confused, because this is in fact exactly what not just President Trump at the time, but the EU and the UK were all saying, we are going to cover everybody. We're buying enough doses. This was very public. But our law and policy paradigm pretended that that was somehow not going to happen. And not only did they push to get their full doses, they pushed to be first in line. And look, low and middle income countries also wanted the same thing. But for some reason, the law and policy response has imagined that, for example, COVAX has said our goal is a 20% goal. 20% of low and middle income countries should be covered. But meanwhile, high income countries are saying 100% is our goal, or at least 70% or 80%. And so if we're not responding through law and policy to what we need, then we're not there. So demand is not the problem. 11 billion doses were needed, but COVAX only set a goal of 20%. They set a goal of 3% by June, but do you know what happened? They only got 88 million doses so far out of 337 million they would have needed in order to get 3% of low and middle income countries covered. And so what we see here is that it's just not happening. The countries are not being able to be sold to because the other countries are first in line. South Africa is a good example. It tried COVAX, it tried a bilateral effort, it offered a high price, it cannot secure doses. And so as we're talking about all of these, what we need to talk about is, in fact, solutions that will give legal certainty and that will give product certainty. And there is some positive movement, right? And so what I hope we see is a much more move toward the kind of open source supply side policy solutions. I'm putting up a tweet because it's breaking news, right? This happened earlier this week that there was an announcement of a new mRNA vaccine hub in South Africa. mRNA vaccines are turning out to be the most effective. They'll be used in the future for HIV, for influenza, for cancer. And so here we've got South Africa along with the World Health Organization saying, we're setting up a vaccine hub. We're going to produce vaccines. We have all the technical know-how. We have the funding. The question is, will you share the recipe? Will Moderna share the recipe? Will Pfizer share the recipe? Will AstraZeneca? Who will do it, right? And so thinking about that should inform us that what we need is a new global paradigm. One that is smart politically, that focuses on what's going to happen in the real world, right? And that uses state power. And so long as we continue to abrogate the responsibility of states, and so long as we decide that we're not going to use state power during the pandemic, we're not going to see the kind of impact we need, and we're not going to even vaguely approach equity. So I'll leave it there. Thanks so much.
Thank you, Matt, for this really great presentation and spot-on analysis, which also concludes the first part of the webinar, namely the presentations. And now I'd like to kick off the Q&A section. Please feel free to continue posting any questions to the Q&A section. I see a lot of questions have already been posed. As a first question, maybe, throughout all of your presentations, it became clear that the current approach is questionable on multiple levels. So COVAX, on the one hand, not really working, on the other hand, being morally questionable, to say the least. And as you, Ruth, have mentioned quite strongly, the TRIPS waiver would also maybe contribute to the solution in the long run, but would also not be of immediate help. So my first question to the panel as a whole, what would be of immediate help then, in your opinion? How should the next steps look? What should the international law approach be? Thank you.
So let me start by, because I've noticed I've been looking at the questions in the chat, and there are push mechanisms, there are pull mechanisms, but I think, as Matt has so wonderfully spoken about, there are policy choices that are being made tacitly that we just need to sort of bring out and all agree that this is what is happening, because it's very difficult. For those of you who are lawyers in the crowd, you can get your case dismissed if you have not stated effectively your cause of action. And that's the scenario we are in, frankly, in this debate, where the choices that are being made are tacitly being made. They're not exposed to the hard reality of the ways in which human rights obligations and even intellectual property objectives are being subverted and undermined. And until we sort of make that clear, it's very difficult, I think, to hold people accountable to the choices that they're making. So just take, for example, the intellectual property system is premised on this notion, which scholars have written ad nauseum, is false. This notion that the inventor sort of sits under an open sky and an idea drops from heaven, and the inventor, with no public intervention and no help, produces an outcome for which he or she should be rewarded. Well, we all know this is not the case. And in particular, in the current context, as Matt has noted, as I've said, and Diane, government action was very much at play in the production and in the success of the COVID-19 vaccines. Why should that kind of model, which is so dependent on government funding, on government regulations, on waivers, and at the domestic level, why should it be subject to the same international intellectual property rules that a widget is subject? And no one is asking this question. And this is why I said earlier that the vaccine gap and the artificial shortages and the further disabling of autonomous health policies to address the needs of citizens is not an accident. It is built into the current system. And until we begin to really hold those political and policy choices to task, we're going to be here some point in the future having another webinar about a vaccine gap or an access gap of some sort, because the system has simply not been built to either foster equity or to enable nation states to comply with their human rights obligations under the International Covenant.
I'll probably be a little bit more blunt and just say point blank that the international economic legal institutions, as I argued back for over a decade now, have been constructed in complete ambivalence to international human rights law. I mean, it's even a miracle if we stop and think that in 2021, people are talking about equity as if there is indeed a space to discuss it in the international economic institutions. But if we flip back to the global economic crisis in 2008 and the notion that austerity measures were being imposed, the whole idea that human rights somehow had anything to do with regulatory decision-making was anathema at the time. I'm very heartened by the fact that more people are accepting and more institutions are accepting of at least the name or the rhetoric of human rights, even if now we contest how exactly we realize it. I mean, my pushback my pushback a little bit to Matthew's great presentation is that I don't think we don't have the law. We do. And I haven't even brought in Articles 55 and 56 of the Charter of the United Nations, right? 55C, which pledges the United Nations to universal respect and promotion for all human rights and fundamental freedoms. 56, which requires all members of the United Nations to take joint and separate action to realize that particular purpose under Article 55. That's a continuing obligation. So the question here today is, I am in complete agreement with Ruth. Why is it that the human rights argument, much as we can hear it over and over again, why doesn't it have efficacy when we talk about the spaces of international decision-making and institutions? This goes back to the same point I've made from the beginning, which is if the international institutions themselves operate without an acceptance that they are also bound by international human rights law, we will perennially have these webinars. We will always have decision-making after the fact, after human rights impacts accrue as they do. I mean, one of the things that I've also been thinking about in regard to the transparency issues that Matthew and Ruth were pointing out is, to this day, we have no transparency in regard to the decisions that are made at the national level, at the regional level, at the local level, but let alone by the private sector actors who have the monopoly of the patents. Moderna said voluntarily it will not enforce its patents. Great, that's an interesting posture to take. But that doesn't come, again, out of a sense of law. It comes out of a sense of social responsibility. And when that is the norm that ties things together, we're going to have disparate attempts to try and realize what ought to be everyone's individual right to the highest attainable standard of physical and mental health, let alone the core right that I haven't talked about, which is the right against the arbitrary deprivation of one's life. It is a stark reality for the developing world that while here in the United States, 150 million people have been vaccinated, we're trying to incentivize people with trips, with groceries, whatever, to try and get a vaccine. For 3/4 of the world, they're arbitrarily being vulnerable to these risks to deprivation of their lives because of where they were born. And the fact that we don't have the transparency in the exact same system that Ruth and Matthew have been talking about is itself a pathology of the fact that there is a wide divide still persisting between international human rights law as it is binding on all states and what they translate and do in international economic institutions. If we want to hold states into account, there are different levers within which to do it. And depending on which jurisdiction you're looking at, you can try and get your state in particular to observe its own treaty obligations. You can also try and use international mechanisms. But for so long as we don't recognize that the impasse is so big with respect to the design of global economic institutions, I agree with Ruth. This is not going to be the first webinar.
And just to add a kind of quick finer point on it, and entirely agreed, this is very live right now, right? There's a kind of conversation that I think is being inspired by some that, like, what we're talking about is, maybe a year from now, we could have a better option, right? That kind of, but this is right now. So just to put like a very technical point on it, Moderna, when they decided that they needed more productive capacity, they reached out to a company called Lonza, based in Switzerland. They contracted with them through their monopoly and extended their monopoly to Lonza. And within 2 months, they were producing more vaccine. So we are in a world where we're talking about, should South Africa do the same? Should Senegal do the same? Should Thailand, should Brazil, should Chile? Where are all the places where there's a huge amount of know-how, smarts, capacity, and frankly, $4 billion put out by the World Bank that's supposed to be being able to be used for this. And yet the legal and policy response is so constrained that we're pecking at the kind of, at the little bits here and there, instead of saying, no, states need to act concertedly. They need to use the authority that exists. Powerful states have an obligation. And I'm with you, Diane. And I think that that's right. And also there's, the challenge of compliance as a political scientist. This is the thing that drives us crazy, right? There is, clear compliance mechanisms built into the WTO. And that's why we're talking about a waiver. There's zero compliance mechanisms for, the sharing of technologies and the sharing of doses. And so with that understanding, we have to say, how do we actually build the pressure to actually use the tools? Because the United States has 100% of the legal authority to share the Moderna vaccine tomorrow. The South African government's called the bluff, right? And said, look, we now have the hub. Will you share the technology? So far, the answer has been no, but that's going to be the core question. Or are you going to continue to kind of drag your feet at the World Trade Organization? The last, as Ruth was saying, the last waiver was negotiated. It took 9 months. We don't have 9 months, but this could be concluded tomorrow. Anyway, thanks.
There are a lot of questions in the chat about human rights and I want to actually say something because I know there are a lot of human rights scholars and my dear friend Larry Helfer, I see on the line, and Graham Dutfield. So, and Larry asks a question about why there has been different traction of human rights arguments in the HIV, AIDS, and COVID contexts. We saw those arguments being effective in the late 1990s, early 2000s, and yet they seem to be far less impactful today. So I think from my perspective, there are a number of things. I do think, Larry, that nationalist populism, to Matthew's point, it would be anti-democratic to expect the president of the United States to say, I'm going to take care of the citizens of Venezuela before I take care of the citizens of the United States. No president with any moral sense is going to do that. So nationalism is here to stay. And I think human rights scholars, intellectual property scholars need to acknowledge this in the way in which we do our scholarship, that nationalism, when it comes to caring for the health needs of a particular set of citizens of a particular country, is going to be the operating principle. I think that our experience with HIV/AIDS was a little different, right? No one saw pictures of US citizens dying on the streets and bodies being piled up on the streets, right? The visual picture of South Africans dying by the thousands daily because there was no access to antiretrovirals shocked, I think, the conscience of the world. But even then, remember the battle, to Matthew's point, it was 9 months to negotiate a waiver. All of the legal systems we put in place to make access more possible have not worked. There's been a stranglehold on them, and this is a challenge. So I think nationalism is going to be added to the other cadre of problems that we see. But in addition, I think that there is the ambivalence within human rights itself. And this is a challenge for human rights scholars. There is a human rights provision that supports intellectual property as a human right. Navigating the normative and the institutional and the political consequences of a human rights commitment to intellectual property makes the legal scholarship in this field, particularly with access to medicines, very, very difficult. My own view is that we need to begin thinking about access to vaccines, to public health, more like we think of security, where the security interests, and of course there's a huge literature in the economic development field of the relationship between health and national security. But in terms of our analysis of the legal instruments at play, that the security paradigm with its clear-cut exceptionalism in all of the international institutions has got to look, we've got to look a lot more like that than we do an economic regime in which the balancing and the nuance forces concessions before one has even left the table. But this is as Larry knows well, and several other human rights scholars, that this tension within the human rights field is quite problematic. Larry's work on this has been very illuminating, and I think we need to give additional attention to that if human rights is going to have the kind of impact, moral impact, that we expect it to have. I also think finally that someone asked why IP academics have not been as supportive of the intellectual property waiver. And I think it's because there is, even for those who are supportive of the waiver in principle, we recognize that a waiver is just like a waiver during the HIV pandemic. No waiver is going to deal with what Matthew has described, and that is the technology gap. You can waive a patent, but that doesn't mean vaccines are going to be produced anytime soon. Given that the patent issue is not just on the vaccine, there are patents on the compounds, there are patents on the delivery methods. Since the 1990s, patent protection for pharmaceuticals has widened astronomically. It used to be that you had patents only on a few number of things. But since the 1980s, you can now get patents for primary uses, for processes and intermediates, for bulk forms, for simple formulations, for compositions of matter. In other words, we are just seeing an expansion of what is covered by the patent. So even if you got a waiver on the patent for the vaccine, what about all the other patents that are affected? Patents on methods of treatment, patents on packaging, patents on delivery profiles, patents on dosing regimes, patent on the dosing range, patents on the dosing route. I mean, if we had time and I could show you all the things that you could get patented, the waiver on the vaccine is just the tip of a very, very big iceberg.
Yes, yeah, thank you, Ruth, for this very interesting elaboration. And I don't know if you, Matt, or Diane have anything to add on that specific question. But If not, I would give the floor to Pierre, who unfortunately has to leave us soon for a different commitment. But
I'm not a member of the panel. I just abuse my position of having also a camera here so that I can ask a question. And I think two questions I wanted to ask, and I think some of them are maybe a bit answered already, but I want to still ask them. One is very specific, I guess, to Ruth about how we understand the TRIPS agreement. Because, I mean, as Matthew pointed out, you know, the financing of these vaccines is so different, right? I find it quite interesting, your Dolly Parton example and, you know, the 99% and so on. And so, I mean, just from a more really international law question, can we not make use of this when we approach all these rules within TRIPS that you have shown us? Like, can we not say, I don't know, we understand Article 31, as you pointed out, more expansively here, simply because, you know, the rationale of the TRIPS is that you have two different interests at stake. At the one hand, the protection of the companies, at the other hand, also the protection of those who want to benefit from the patents. And that just really technically, in the sense of Article 31 of the Vienna Convention on the Law of Treaties, object and purpose interpretation, can we not say, like, if we look at the object and purpose of TRIPS, that this, in the COVID case, cannot apply because this balance is not the same, because all this research was essentially funded by states? Is that not maybe a way how we can get out of these TRIPS questions? And the second question relates a bit to what you then said, Ruth, about patents on everything, essentially, and that it won't help if we have a patent on the vaccine itself. And that brings me really to the companies, you know, and this is maybe a bit something that we could also address a bit more. We've been a bit state-focused, I believe, in the moment in our discussion. But, you know, in a time where we have the United Nations guiding principles on business and human rights, which have just had their 10 years anniversary, where we have the acceptance that also, or the increasing acceptance that also international corporations have at least the human rights responsibility, you know, where do they come in this discussion? I mean, can we not somehow also make these arguments that Diane pointed out on the ICESCR? How do the companies, the corporations, the responsibility of the corporations come in this discussion? That would be my questions. So the one, I guess, more to Ruth, the other one more to Diane.
So I'll try and address the question on my angle. There is a duty to regulate on the part of states, at least on the Covenant on Economic, Social, Cultural Rights. We know General Comment 24 from the committee elaborated at length on how states have to regulate business activities in a way that will not defeat respect, protection, and fulfillment of covenant rights. But beyond that, I'm also thinking of the fact that, you know, there may be ongoing efforts on the business and human rights fronts, but also beyond the specific nexus and interface of how states have to act in regard to businesses. The relevant jurisdiction we're looking here is the United States, right? And the question is how to get the United States to regulate it. It has already committed to a waiver, but we know that will take time. So how do we get the United States to think that part of its own international responsibilities or its own legal duties include possibly enabling or incentivizing its own companies to join, say, the COVID technology access pool, which frankly has been open for quite a while, and it hasn't been there in regard to technology transfer issues involving the vaccines and the entire phalanx of technologies related to vaccines. This is where I do think mobilization does have to happen at the United Nations, because much as the United Nations has said, this is a human rights response to the pandemic, it also hasn't focused on how that human rights response is not just directed towards issues involving lockdowns and what have you, what are, you know, prophylactic responses, but the entire anticipatory response of prevention, treatment, and control. There's been so much deference placed to the World Health Organization to marshal the response. But the unfortunate thing is the World Health Organization almost barely recognizes human rights obligations in its policies addressed to this pandemic. And that's still a thorny sticking point. I mean, the United States can very well say, we're doing the bare minimum of what's required. With respect to the WHO, we're doing better than the European Union. But because this hasn't risen to the level of a charter issue involving universal respect and protection for human rights, something that is actively debated, actively put on the agenda at the General Assembly, actively pushed for at all levels, instead of being siloed, say at the World Health Organization, or at UNDP, or in the latest report on what is the COVID-19 response on women. Instead of being siloed, but put at the highest level of urgency, there's still a natural tendency to look at this as, well, the inequality is inevitable. It's there, it exists, and it's a given and token fact. Until we see this level of prominence in the discussions at the international level, I don't quite see this moving the needle for decision makers involved in trying to marshal the necessary cooperation. I mean, we're still looking at it in a very compartmentalized human rights approach. It's a single norm here, it's a single norm there, as opposed to what I would think at this point it has to be at the level, the highest level of charter norms and cooperation designed at that level.
So I think in addition to what Diane has shared, something that's important, Graham Dutfield had put in the chat the notion of the use of state power to force companies back in 1944-45 during the war. And that's how they had to share their know-how and their recipes, essentially their trade secrets, to maximize the production of penicillin. I think that one of the greatest leverages, certainly for human rights, it's capacity to speak to state power, because that's in the DNA of the human rights regime in a way that it is not in the DNA of the intellectual property regime. But to Pierre's point, state power actually is much more of a nervous expression, a nervous position when you're speaking of private property. And so the idea of the vaccines having been produced by government funds not being private property is one that I think has a lot of appeal. Here's the challenge, and this is something that I'm working on now. The US government, for example, owns patents. And many OECD member countries have not taken themselves as states out of the patent owning business. And so we're seeing, as if there are any antitrust scholars on the call, we're seeing a situation in which the state is itself a market actor, acting like a market participant. And that makes the appeal of the kind of blunt argument that Pierre was making much harder to deploy, because the state sees itself, in a sense, as being in the market, acting with the market to produce these vaccines. But I think that there's a powerful both human rights and constitutional argument and international law argument that this cannot be the appropriate role of the state, and that where public funding has been involved, citizens are paying twice. Citizens are paying not only for the funds that supported the research, but then paying again by having to purchase the drugs. So I think that it's an important argument conceptually to make, and that it has a lot of important doctrinal power. And the question is whether this historic, since 1883, states have been so entrenched in the intellectual property system that we now have over a century of jurisprudence in which the state views itself in the IP realm as protecting its citizens, and therefore any incursion is the state failing its duty. And this is something that I think both human rights scholars and intellectual property scholars really need to think about, because I think it's ironic that we have nationalism that has reared its head so clearly, and yet the system is being run on a global basis. So if it was just nationalism and Moderna was only producing for US citizens, that's one thing. But Moderna, with its patent, gets to exclude everybody else from producing. And there's no logic to that in the face of nationalism. So nationalism says to me that there may be opportunities for us to think about long established principles of the international patent system. For example, the principle that says that you cannot require local working of a patent. Well, what's the point of nationalism if the US can hoard it, or Canada or anybody else, but Tanzania or Kenya or Cameroon is stuck with a global patent system that says you cannot require Moderna to actually produce vaccines, and you cannot produce them themselves, and you cannot have access to the know-how. So we're seeing a progressive disabling of human rights levers and a progressive disabling of democratic levers in the area of public health. And we're seeing an enlarging of property and nationalism in a way that is counterproductive to both the goals of human rights and the goals of intellectual property.
And I think just to add briefly, I mean, the just in radical agreement to say that pandemics are unique, right? They're unique because they're global. There's a simultaneous need for access. There's shared risk that exists. To Larry's point, you know, it's just worth noting, it took years for the HIV response to actually mobilize the human rights paradigms successfully. That was not, you know, we're now, you know, if we're going to use the HIV example, we've got another 5 years before countries even begin to get access. So I think there's a real problem here, right? And it means that we need to pay attention to global law and where state power is being mobilized, right? And pay attention to compliance. I'm a little bit suspicious of some of the conversations around a pandemic treaty because they're only taking place in the area of soft law, right? The World Health Organization, which has no compliance mechanisms, as we're seeing, it's in the world of human rights where we got, instead of actually talking about hard compliance mechanisms. And so if we're going to talk about expecting companies to act against their fiduciary interest, and it's just worth noting states are acting here, right? The United States has put export restrictions. Europe has put export restrictions. They are using state power. It's just that they're using it for nationalist outcomes, right? They're also using political power. It's not a mistake that Israel has access to a lot more doses than any other country in the region. That's about political and diplomatic power. And so I think there's two pieces to think through. One is, how do we compel action by private actors? And this is where, you know, there's a note in here from Pedro Villarreal about, you know, kind of the use of putting obligations into contracts. And I think that's an important piece. Where countries are funding research and development that are publicly funded, there should be elements required and agreed transnationally that say that actually there need to be access provisions once the product is developed on the front end. Don't worry about it at the back end, because we're going to lose that fight every single time. We have to do it on the front end. That's where the human rights obligations should come in. And then increasingly, I think we need to talk about WTO's relevance. I think part of why you see Secretary General Ngozi really taking up the reins of the waiver is that she sees that this is going to define whether or not the WTO is relevant. If the WTO's only role in a pandemic that affects the entire world economy and collapses it is to be a barrier to access and a barrier to solving the end of the pandemic, then the WTO is in deep trouble. So a bare minimum would be an immediate legal mechanism that says when there's a declared public health emergency, there's an automatic TRIPS waiver, right? There's automatic funds that flow. These are the kind of basic things that would actually have some teeth to them. And so I think we need to be talking and playing in the world of the WTO much more than the world of the WHO to solve these problems, because we need to pay attention where the power is. And that's where the compliance mechanisms are. So,
well, Matthew, if I may just add on this point, especially in regard to what's being put in the contracts. Over and over, we're getting trickles, piecemeal information about what's really being negotiated within these contracts. There's no active civil society that can actually monitor the production sharing agreements or what the particular purchase order agreements are. There are reports that Pfizer has required governments to put up sovereign assets as collateral, as guarantee against indemnity, for indemnity clauses in these contracts. Now, to the extent that, especially in a time of mass lockdowns all over the world, it's even harder for human rights advocates to mobilize, especially in the shadow of virtually no information that's being disclosed by the private sector, as well as the governments that negotiate with them. One of the low-hanging fruit that governments could already do without need of requiring expenditure is a policy of absolute transparency for all of these contracts, for all of these particular agreements. The fact that we're at June 2021 and still I haven't seen an actual template contract from Pfizer or Moderna involving the kind of terms, required terms that they have, either for future uses of the vaccine or any possible collateral of sovereign assets, which was, I think, one of the most disturbing things that I saw recently put out in the news. That's being undertaken by governments without accountability to the populations that they represent. So let's look for I agree with you absolutely. The WTO definitely has to be the theater for discussion in many of these. But for me, it's also as simple as if we are truly committed to vaccine equity, then it has to be equity in full transparency, not with the fomenting of inequality on the basis of favoring certain constituencies more than others, to the extent that none of us know exactly what those terms are.
Thank you, Diane. That already brings me to a possible last question. As I see, we are already a bit over our allocated time, but maybe if everyone has the time, because a lot of questions have come up in that regard. For example, Gabriel Amas Cardona asks, what mechanisms or approach are possible besides naming and shaming to shift discourse towards equity? I must say, as the Völkerrechtsblog is streaming the event, they also had a symposium recently on rewarding in international law. But that was a question that was quite often in the chat. So if you could maybe wrap up in 1 or 2 sentences, what are your takeaways, the lessons learned from the pandemic to really reform the system, if you could bring that down to 1 or 2 points. And any of you can go first, of course.
Well, I will leave the last words to the far smarter panelists than I, but let me just say two thoughts. One, on Gabriel's point, I think that this is where there was an imagination, I think, in the current law and policy paradigm that somehow the norms of sharing vaccine doses would be strong enough to compel states to act. We now have evidence, right? There can be and there should be no further debate. Will countries act against their narrow nationalist interests? The answer to this is no. And therefore, let us not build any further policy paradigms that expect that to happen. Let us not do a pandemic preparedness treaty that depends on voluntary state action to ensure equity. It's not going to work. And there was an idea that because it's a pandemic, every country in the world has a deep interest, an economic interest and a global health security interest in stopping the pandemic. And the way to do that is to share technology. The way to do that is to share doses. And therefore, countries would do that. That was the theory. It did not work. So there's conversations right now about making Act A and COVAX permanent. I think we just need to be honest that this does not work. So what are the other options? How do we shift to a different paradigm? And I think this is where part of what Ruth is saying is just so clear. There is another paradigm out there. Right? The other paradigm is an openness paradigm, that instead of what the conversation is about sharing doses, the conversation needs to be about sharing technology and sharing know-how. And if we can get to a place where that's the core conversation, then we can talk about where should the factories be. We should note that where factories are in high-income countries, they have never once served the interests of low-income countries well. Never. Ever, 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 right? So I would love somebody to bring me the example of where I'm wrong, and I will take it back. But I haven't found it yet. I'm looking for it. So if you find it, please let me know. The bottom line is we should just know that the reality of low income countries, they are going to sink or swim based on how scarce the good is and where the good is produced. And so if we know that to be true, then equity is about sharing the knowledge, sharing the technology base, and ramping up the ability to manufacture. That's what Southern leaders are talking about right now, and we need to take that seriously. And so I would love if kind of the international law world focused a bit on what would the tools in the arsenal look like to give Southern leaders their ability to do that in the medium and long term, and redirect the conversation away from some of the kind of voluntary mechanisms that are just failing deeply. Thank you all.
I think my short answer to this is that in 2021, we are way past the era of naming and shaming when you have governments that are shameless. So when you have politicians that don't have a sense of shame, that's not a strategy that's going to work. I take a lot of inspiration from the landmark business and human rights victories in national courts. And we've seen that play out with cases like Vedanta, Okediji versus Shell, among others, in individual courts that can pressure governments to fulfill their obligations. I mean, just recently, we saw the landmark victory at the Netherlands with respect to compelling Shell to suddenly say, well, it's not enough. You have to drop your emissions by 45% within this certain time horizon. There is a possibility for national courts to compel governments to act so that we're no longer just in the era of trying to persuade policymakers, but actually telling policymakers there are legal consequences within your individual jurisdictions for the failure to act. That said, apart from national litigation, national court litigation that I've seen gain so much traction in the business and human rights and climate litigation space, I agree with Matthew. There's a lot that can be done in law and policy, but there's also the kind of litigation that can be brought in regulatory agencies. I mean, surprisingly, we're looking at things like investment agreements or contracts. Those are things that don't necessarily have to go to the level of the Supreme Court or an international court. You can exercise and push the lever with respect to the parties concerned in the most localized subsidiary way of trying to enforce transparency, of trying to ensure that contracts are not contrary to public policy. I mean, that's a standard legal doctrine that all contracts must be negotiated within the shadow of public policy. So to that extent, if it requires not just compelling disclosure of contracts, but ultimately invalidating them, that's a concrete disincentive for the market actors involved, knowing that their particular transactions may not take place if they're actually proven to be contrary to public policy, which does include human rights law.
So I'm going to end with something that somebody in the audience who's a PhD student might be able to run with. A couple of things. The first is we often in these conversations assume that the developing countries and the least developed countries are the victims. And I want to suggest here that it's important to also in this discourse identify the responsibility and the role of developing and least developed countries. Many of the national leaders have not used the legal tools that are available. And as scholars, we always add to the toolkit, but the ones that are there are in fact not used. And this is a human rights violation on the part of those countries. And it's important that in the classic liberal progressive paradigms in which these conversations occur, that we don't treat these countries as just victims, that they are also responsible and should be accountable for utilizing the legal tools to advance the interests of their citizens. So, and that is true in the human rights space. It is very true in the intellectual property space and the TRIPS agreement as well. Second, I think it's very important that there be a clarity about the goal of the human rights litigation, which is to essentially identify the ways in which these systemic abuses have an obligation of international law to be stopped, and the goal of intellectual property litigation, which is to challenge, as Pierre suggested, the narrative that there is a monopoly reward that only one company ought to get. Moderna and Pfizer are making lots of money, and I'm very happy for them. But at some point, we have to ask the question, is intellectual property over pharmaceuticals the way we want to build national wealth? Because if that's the way we want to build national wealth, we shouldn't be having this webinar.
Yes, I think those were great closing remarks, Ruth. Thank you, and thank all three of you for really a wonderful discussion. And yeah, we have unfortunately already surpassed the time limit of our webinar. I'm very thankful that you stayed with us to answer some of those really interesting and pressing questions. And yes, thank you three so much for having taken the time to join us today and for your insightful presentations and the really engaged discussion. It was a pleasure to host this webinar. I would also like to thank everyone at the Institute who helped organize this event, in particular our co-organizer, Sissi Kazzoni, and our student assistant, Sonja Schäfer, and everyone involved in our research cluster on human rights and humanitarian protection. And last but not least, of course, I would like to thank every member of our audience for joining us today and for posing questions, for an engaged discussion. And I really hope you have taken something out of this webinar. I certainly have. So yes, thank you.
I did too. Yes, before we close this webinar, we want to also warmly invite you to join us for our second part of this webinar series, which will take place on Monday morning and which will address the COVID-19 vaccinations and their human rights implications. The event will feature presentations by Marko Milanovic on freedom of expression and anti-vaccination activism, Iris Goldner-Lang on vaccinations for vocation, the pros and cons of EU COVID certificates, and Sissi Kazzoni on compulsory vaccinations and human rights. We have posted the registration link in the chat already, and we're looking forward to hopefully welcoming you back on Monday. Thank you all for joining us today. It really has been a pleasure to host this event.